Today we're breaking down a critical but often overlooked compliance obligation under FINRA Rule 3280, the rules governing Private Securities Transactions, or PSTs. Most people think PSTs only apply when a representative engages in a securities transaction where they sell away from their broker-dealer. But in reality, the obligation is much broader. It also extends to personal investments in corporations, limited liability companies, or limited partnerships that are made away from the firm. That means even a purely passive investment, made for your own account and not involving client solicitation, may still qualify as a PST and must be disclosed. Before engaging in a PST, an associated person must provide prior written notice to their firm. That notice must describe the transaction, the role of the individual, and whether any selling compensation is involved. If compensation is to be received, the firm must approve or disapprove in writing, record the transaction on its books, and supervise it as if the trade occurred within the firm. If there is no compensation, or it's a passive investment, the firm is still obligated to acknowledge receipt of the notice, even if active supervision isn't required. This matters because failing to disclose a PST, compensated or not, is a violation of Rule 3280 and can trigger disciplinary action, regulatory sanctions, and reputational harm. And the obligation is two-sided. Firms must respond, record, and supervise as appropriate, or they too face exposure to fines and enforcement actions. Here are best practices for associated persons. Review your firm's written supervisory procedures. Disclose all private LLC or LP investments acquired away from your firm, even if personal and passive. Submit the required written notice and keep records of the firm's response. And here are best practices for firms. Clearly define PSTs and supervisory procedures. Review PSTs for conflict of interest and determine if restrictions are necessary. Train representatives regularly on disclosure obligations. Centralize the notice and approval process. Periodically monitor and review outside investments to catch unreported activity. The bottom line is simple. Private, corporate, LLC, and LP investments are often treated as PSTs under FINRA Rule 3280. Both firms and representatives share responsibility for disclosure, approval, and record keeping. Taking a proactive approach to compliance today helps avoid regulatory scrutiny tomorrow. At Legay Law Firm PC, we make regulations make sense. Hit subscribe, and for timely regulatory updates, join our email list through the link in the description. www.legaylaw.com